Companies Act. A special presentation by The Firm.
If there is one section in the Companies Act 2013 that every company in this country wishes did not exist, it is Section 188, Related Party Transactions. What's so wrong with this section and what kind of problems is it causing India Inc.? To discuss that, I have with me today M&M's V. Parthasarathy, EY's Dolphy D'Souza and the Tata Group's Bharat Vasani. Gentlemen, to all three of you, a very warm welcome. Before we begin the discussion, here's an overview of the scope of Section 188. Firstly, it applies to all companies, listed or not. It covers a variety of transactions entered into with related parties, except transactions in the ordinary course of business and at arm's length are excluded. All others must obtain audit committee approval and board approval. They must also be disclosed in the board's report to shareholders along with the justification for entering the transaction. Of these, transactions entered into by a company with 10 crore rupees and more of share capital, or transactions exceeding certain prescribed size thresholds in the rules, must be approved by shareholders via a special resolution. The related party connected to the transaction cannot vote on the special resolution. Well, the wording is vague here, but we'll come to that later. So that's the related party regime. Now, let's go back to the beginning, to the definition of related party. The definition runs long and wide and includes a director or key managerial personnel and his relatives. Relative is separately defined to include 2 generations and siblings and their spouses. That's 8 relations in all, whether or not they are financially dependent on the director or the key MP. The related party definition also includes companies in which they serve as directors, managers, or partners, or companies that act on their advice. And of course, it includes holding, subsidiary, and associate companies and other subsidiaries of its parent. That's a large family of related parties and not devoid of absurdities. For instance, subsection 5 implies that if an independent director is on the board of 2 otherwise unrelated companies, his directorship would make them related. The ministry has only this week removed that difficulty. After months of confusion, another amendment to the rules clarifies that a director, other than an independent director or a KMP of a holding company or his relative, are related parties, implying that an independent director of a holding company can now serve on the board of a subsidiary company as independent. But there's more cleaning up to be done.
There's a very serious lacuna which they should have plugged, which is not plugged, which is the previous subclause, which is subclause 4, dealing with private companies. World over, the abusive RPTs happen when in private companies are controlled by directors' relatives. In that clause, they missed out relative. All other clauses, the word relative is there. In private companies, the word relative is missed out. So effectively, a director's wife can control 100% of a private company and can have an interior designing contract for the entire office, still not covered by Section 2, subsection 76. So in my opinion, that's a very, very serious lacuna which they should plug it.
On the issue of definitions, Dolphy, there are a couple of things that are undefined as of now. For instance, those transactions that are at arm's length and in the ordinary course of business, would not come under the scope of 188.
Right.
But these 2 concepts are undefined or poorly defined or loosely defined. There are different interpretations out there.
I think the important aspect of this is the ordinary course. If a technology company is buying a real estate company, then there is certainly something wrong.
Right.
And that's not in the ordinary course, and that's where the shareholders come in for an approval process. I think that's perfectly fair. As far as arm's length is concerned, it is a very judgmental concept, and it would be based on facts and circumstances of each case. The income tax transfer pricing legislation would provide some persuasive evidence of what's at arm's length and what is not at arm's length. To just give you an example, so let's say there is a hotel that's providing a better discount to the related parties. Now that would still be treated as arm's length because it's got a huge corporate customer, and for that reason it's giving a discount. So I think it would be based on facts and circumstances of each case, and it would essentially be judgmental. Having said that, there would be some disputes and we can't rule that out. So for example, if your transfer pricing legislation you have agreed your transfer pricing based on safe harbor rules and said, look, my margin is 29%, would that be acceptable under Companies Act or not? I think the bottom line is, are you depriving minority shareholders of some value? If you're not, if you have got that fact right, then I don't think that's
I have a view on what Dolphy said. The objectives of the two statutes, the transfer pricing, which is a fiscal statute, and Section 188, which is a minority protection provisions, are different. It would be, I think, hazardous for the board or an audit committee to entirely rely on these transfer pricing methods to determine whether a particular transaction is at arm's length.
So you need guidance from the ministry on what they mean by these two concepts.
According to me, apart from the guidance, the guidance can never be comprehensive. They need to, the board and the audit committee needs to exercise independent judgment to come to a view. You can't go on taking 3 quotations every time, otherwise you are bureaucratizing the boards and the audit committees. So you need to take a judgment call, and you need to take an independent view that in our opinion this transaction is at arm's length. For example, we have situations where there are 100% subsidiaries, and that is also not carved out. And the board has to take a call whether this transaction is an ordinary course or arm's length.
No, I just wanted to go back, and this, I got almost 60 companies together, and I was trying to explain what's the difference between the last act and this. The last act is only talking about association of directors. That means their relatives, the company in which they are interested. Now there are 3 layers: the director, the company itself, and the KMPs. So, the multiplication is not just 3-fold, maybe 27-fold because of the association. And with clause 49, it says
I haven't
even
brought SEBI into the mixes yet, but nonetheless, yeah.
So if you add to it, because it adds to the definition, it says an associate is related. So if I have a joint venture partner in one end in trucks and the joint venture partner maybe in IT services, both will become related.
SEBI's new Clause 49 adds another layer of complexity for listed companies. It expands the definition of related party to include those in control, joint control, or having significant influence. It also includes entities related to a company if they are members of the same group, if one entity is an associate or joint venture of the other, and if both entities are joint ventures of the same third party. Clause 49 also says all material related party transactions need shareholder approval via a special resolution. Material is defined as transactions exceeding 5% of annual turnover or 25% of net worth. There are no exemptions for transactions in the ordinary course of business and at arm's length.
I was joking just before I started this session by saying, like we say, all Indians are, brothers and sisters. I think everybody under the new Companies Act with Clause 49 are relatives. Everybody.
I think the problem with the SEBI requirements is practically all transactions are covered. Because they're talking about resources, not even assets. So there may be resources which are not yet assets, but they're still covered under SEBI
They
regulation.
also cover transactions that are done free of charge, right?
But that would be under Companies Act also, because free of charge would mean that the transaction is not at arm's length.
Okay.
So the SEBI requirements, I think they are very onerous in the sense that there is no arm's length and ordinary course exemption, and therefore any transaction that's greater than 5% of turnover or 20% of net worth would be covered. So your normal royalty payments in certain cases would have to go to shareholders' approval where only minorities vote. I think that is really fundamentally a big issue in my mind.
But shouldn't normal royalty payments go to minority for approval? For instance, and let me give you the example and where I'm coming from, we've seen a large number of companies in this country, either subsidiaries of MNCs or now even subsidiaries in large Indian groups, pay their parent company or sometimes even the promoter's company a royalty, whether it's for the brand or it's for technology, etc. And in some cases, the amount of that royalty has been fairly high and divergent from industry standard. Shouldn't minority get an opportunity to vote on this, even though we haven't yet started talking about the approval system? So I'm saying, why should these transactions not be covered?
Unless they're abusive, but if they're not abusive and you have a whole process of approval, the management approves it, the board approves it, the audit committee approves it, then I don't think if you have gone through all these processes and they have come to a view that this is not really abusive, then put that to shareholders. And if it is really abusive and all these entities have approved it, then obviously there would be noise from proxy advisory firms and the company would be compelled to do otherwise. But I don't think in all those cases which royalty payments are at arm's length, you need to have shareholders' approval.
Okay, we'll come to approvals in just a bit, Mr. Vasani, but just the kinds of transactions that are covered thanks to Section 188 and the kinds of transactions that get covered thanks to SEBI Clause 49.
I think we can discuss for 3 consecutive shows only on that topic. So
Okay,
to be very brief, the Section 188 itself is very wide. In fact, it encompasses several transactions which are separately regulated by Companies Act itself. For example, all transactions dealing with corporate restructuring, mergers, demergers, hiving off are all covered by 188. Now, they are also subject to a separate discipline under the current Companies Act, sections 391 to 394, and going forward when the new sections are notified, 231 to 234. Yeah. There's a very separate process prescribed, but 188 is silent, and it's today unclear whether you have to comply with the discipline of both the court approval, the notice to Competition Commission, all the process under that, those sections, as well as under the Companies Act. Secondly,
as well as under 188.
As well as under Section 188 of the Companies Act. Similarly, guarantees. A holding company gives a guarantee to subsidiary, a very routine commercial transaction, day in and day out it happens. You cover only under Section 186, or you need to also subject it to the discipline, since holding subsidiary are related parties, discipline of Section 188.
On guarantees, I think I have a different point of view, because 186 applies to people who provide guarantees, not to recipients of guarantees, whereas 188 would apply to both.
The recipient, okay.
And if a guarantee is not at arm's length, then it should certainly be covered. Also, I think with regards to legislation, what we have seen in the past is when there is company law and when there is SEBI law, what we do is let's say company law says you need to have 3 independent directors and SEBI requires 4 independent directors, then you take the higher limit and have 4 independent directors on your board. So also I think with these provisions of 186, 188, I think it should go through a higher requirement of 188, particularly when that transaction is not at arm's length.
Take another example, trademark license agreement, very common for most companies. The word used is lease and not license. But it is providing a trademark. Is it also a service? Whether it comes under a different clause, which is subclause D of Section 188, then effectively even whole trademark license agreement effectively will be covered under 188 and will be subject to the discipline of majority of minority. And these are the transactions where audit committee may take a view that we are not in a position to decide whether it's arm's length or not. And many of the times, these trademark license valuations and are very, very technical subjects. So they would say, I would like to have an accounting firm opinion.
Companies Act, a special presentation by The Firm.
Now we're talking about approvals. Only those which are not in the ordinary course of business and not at arm's length will require majority of minority approval?
Absolutely.
Right?
Right. That is correct, as per Companies Act. Yeah. So now the question is that what is the list of such transactions? Because who is going to judge till the definition comes at what are arm's length? Everything in the grey area.
You're going
then
to put
the audit committee will say, yeah, we will take it to the shareholders.
So how long will the list be at, let's say, the parent company of your group, which is M&M?
It will be a very long.
Give me how many pages so that shareholders. How many pages?
Let me come to the first one, but it will be maybe 20 pages or
20 pages of single line transaction listing.
Yeah, it will be that kind of a list which will go to it, and then we will say that, listen, I don't know whether it's arm's length or not, but this is what. Let me give you an example, and this is a very simple example. I have a ERP platform, say SAP platform, which I am doing for the head office. Anyway, M&M Limited does this. So I am now providing a little service for the next company which comes up, which is a related company, and say I am going to charge him on marginal cost. Now, is it arm's length or not? I am saying I am going to go to the shareholder and anyway declare to them and let them approve it. Now, this kind of all transactions which normally I would have never dreamt of taking it would now be part of the scrutiny. And your point about do the shareholders actually need to look at some of the big transactions? Yes. But if that gets lost in buried in the 20 pages, who is gaining?
Parthasarathy, what I felt is that perhaps you can bring some discipline into it by saying that there is nothing in Section 177 which mandates that it needs to be approved by audit committee, that the board can prescribe certain materiality thresholds. There is nothing which says you can do it. There is nothing which says you can't
do it either.
So I think perhaps it may be prudent for the board to prescribe certain materiality thresholds under 177 so that not very trivial transactions go to the audit committee. Otherwise, you are reducing the audit committee's role to that of an operating manager.
India is a country where there is a lot of concentrated ownership. OECD has done a study and they have found that on an average 57% of the shares are held by promoters and with a lot of web of companies. So the possibility of abuse is increased manifold.
Yeah.
So I agree with the principles in 188 where board has to approve. and shareholders have to approve. But there are a lot of things in the drafting, whether it's in respect of the definition, materiality, transaction, that has to be substantially changed.
The drafting bit seems to imply that no related party can vote on that transaction, not just the related party connected to that transaction which is being put to vote. That's something that needs to get cleaned up.
The concept between an interested related party
And an uninterested.
and uninterested is an important distinction to make.
Our view really is that it's not a related party of the company, but related party who is in conflict with that transaction should not vote.
The second thing is the legal concept of depriving a shareholder the ability to vote on
See,
this.
I have one
I'm
fundamental
sure you're
view
going
on
to
this.
say that is also going to get challenged.
The cardinal principle of company law is that shareholder is not acting as a fiduciary for someone else, unlike directors. So shareholder is entitled to act selfishly in his own economic interest. Now you are reversing that cardinal principle. I do realize that several countries in the world have done it. But I have studied all of them and I find that all countries have done it only for publicly listed companies. We have gone further to even cover it to unlisted companies, and I believe the private companies now there is a proposal to carve them out under the proposed notification they are going to issue. But this leads to, can you just take away right of a majority to vote on a transaction? That's one part. Second very larger issue they have raised is that they have said for listed company it's a prosecution, you go to jail plus fine. Unlisted companies you go just and pay the fine. The issue I have is that without looking at the gravity of the offense, an unlisted company could have done a transaction which is extremely malignant, but without looking at the nature of the offense, you prescribe two different level of punishment, which is also subject to judicial scrutiny under Article 14, that whether it meets the test of reasonable classification, intelligible difference, all those issues will come up. And thirdly, the issue will come up of double jeopardy. Whether SEBI prosecuting you for the same offense and Ministry of Corporate Affairs prosecuting for the same offense, whether it violates the constitutional rule of guaranteed by Article 20 that you cannot be punished for the same offence twice. So there are multiple issues on which this issue will get covered.
Section 188 is accompanied by many implementation problems. For instance, in the case of a wholly owned subsidiary in a transaction with the parent company, how would the wholly owned subsidiary get shareholder approval since the parent can't vote? Thankfully, the rules have fixed that by saying the special resolution passed by the holding company is sufficient. But what if the parent is a foreign company? Can Indian law prevail on it to pass a special resolution?
As far as a foreign company is concerned, you can't apply Indian legislation to foreign shareholders, and they are not going to pass any resolution for an Indian subsidiary. So the related party transaction rule should then only apply to the subsidiary, and if it's got only one shareholder, then
what do you do?
The provision is infructuous, and you say that it does not apply. But again, like many things, the Act would have to be amended for some of these difficulties and some of these problems, because the Act otherwise is not clear, and the rules have further complicated these whole issues.
Let me give one example. I have an associate, and the gratuity trust of this associate is now a related party. So,
because of employees.
Because of employees. Just look at the kind of, what we'll have to do. Just take an implementation issue. I can't appoint a director till my accountant goes through all the related party and says this is the prior approval that has to be taken before he is even appointed. So these are the kind of issues it's going to throw up.
Yeah, I think the problem with the clause 49 definition is they have picked up the IFRS definition, which essentially relates to disclosure requirements. So they're saying that if you pay something to your provident fund, you have to disclose. Now they have used that definition also for approvals. And therefore, if you pay to your provident fund greater than 5% of your turnover or 20% of net worth, which could be a very rare instance, but you would need shareholders' approval. And that's where the problem is.
One of my company, I wouldn't name it, there are 1,700 parties we have to examine to get
1,700?
Yeah. So the question today I have is that you create a regime where you have to monitor so many transactions. Now they have to be appointed to go to the audit committee for prior approval. And if one way to take a view that there is no threshold applicable, imagine the plight of the audit committee members, and I'm telling you, some of the audit committee members have confided in me that they're finding it too tough to handle it because of the fact that everything comes. Fortunately, not in a group like ours, but there could be unscrupulous promoters. Now the transaction requires approval by audit committee, not by the board.
Yeah.
So some of the difficult transactions, they pass it on to the audit committee for approving it, and then they say, we have not done it, it's audit committee which has approved the transaction. So
Give
audit
me an illustration of what kind of transaction you're saying where the promoter might shirk away from the responsibility of it.
where some real estate is being sold to a company which is promoter's company, and the transaction comes up before the audit committee, and there may be pressures on the audit committee to approve the transaction. And eventually, if it is approved and they bow down to that pressure, then the problem is that tomorrow, if somebody were to challenge the transaction, the promoters who are genuinely interested in those transactions would go away scot-free that I have not approved it. It's the
audit committee has.
audit committee which has approved it. So
This is what the OECD as well says. That says that audit committee should not approve transactions. They should monitor transactions. If required, they need to investigate transaction. But if you ask them to approve it, you're putting them in the shoes of the management and you're actually stealing their independence from them.
Okay. So let me then ask each one of you for possible solutions whereby you can make this a more livable with section without taking away some of the good features. For instance, there have been several abusive transactions by promoters in the past, and therefore it is a good idea to give shareholders the right to vote down some of these conflicted transactions, and therefore the majority of minority process is a good one. It may not apply to everything that's been discussed here, but how do you retain the good parts of this section and do away with all the crazy, unlivable implementation issues?
Let me take a crack at this.
Sure.
First is that if
From the Companies Act point of view, SEBI
Companies
is
Act.
separate.
Yeah. First is at least can SEBI subscribe to whatever as companies last said. So at least that.
So you
that
have
is
both are aligned.
Yeah, okay, fine.
aligned.
Yeah,
So
convergence.
alignment,
Yeah.
convergence of that. Second is give the financially independence and dependence as an important criteria of the definition. My son-in-law may not
For
listen
relatives.
to me. Yeah,
For
relatives.
relatives,
So
got it.
therefore, that automatically brings in
Okay, so that's
some
the
more
second
this one.
request. Would
Third
you
is-
prefer that instead of the thresholds Companies Act has put in, that we follow the SEBI thresholds because they are materiality thresholds,
Yeah, so-
and therefore you may change the numbers up and down,
Yeah.
but at least they make it more useful that only important large transactions
So if you
have
make
to go through
and
this.
in the add and instead of or in the Companies Act, I think by and large you will get to the same answer.
So 10 crores and more,
And
and these transaction
these
thresholds.
transactions. So automatically then it builds a threshold. I don't know
For
which
those
is
who are
better.
very high thresholds.
They are not very high.
They are
threshold.
10%, 15%.
So
I mean, a
which-
transaction that's
25% of
15%,
turnover.
25% of turnover.
Yeah.
That means only very rare transactions then will come to shareholders
So
for a
if it
vote.
is very
So
much-
somewhere in between.
I don't mind. I'm not studied which is more.
Okay, I get
onerous,
what you're
both
saying.
are thing.
Yeah.
But if you
You
make
can
it
moderate
and,
it, yeah.
then you get some transactions which are really important.
Yeah.
See, what you want the shareholders to know that there is not abuse, and I think
I
that's
get
a
that.
reasonable principle. So I think you and would do.
Okay.
So now let me pass on. So
Okay.
I don't know.
Dolphy, what can we do to make this more livable?
I think just to add to what he's already said, one is the audit committee approval, pre-approval.
Do away with that?
Yeah, I think audit committees should not be in the business of approving these
Okay.
transactions. That is certainly one thing.
Board committee approval? Board approval?
Board approval, certainly.
Yeah,
They are the
yeah,
management, so they should be approving it. I like the principles of majority of minority, particularly when the transaction is not at arm's length and ordinary course.
Right.
But the definition of related parties, the parties who should vote, who should not vote, the definition of related party transactions, and the whole approval mechanism, I think those are
That's
quite
pretty much everything in
challenging.
the section.
Exactly.
Dolphy, that is pretty much everything in the section. So what you all are suggesting is that maybe somebody in the ministry should defer the applicability of Section 188 for a year, clean up some of the drafting issues, moderate some of the thresholds, get SEBI to see the same point of view as the MCA and align their Clause 49 requirements on RPTs, and only then bring this into force.
Yeah, that's perfectly legally possible. They can re-notify effective 1st April 2015 instead of 14 and make the provisions workable.
If none of this happens,
Yeah.
then what kind of soup are you in?
In a hot soup.
Companies Act. A special presentation by The Firm.